Hello everyone. Welcome back to our channel US Immigration. We hope you're doing great. In this video, we will talk about the US immigration good news. Recent US immigration updates have introduced several key changes that could significantly affect your application process. For those navigating family unity cases and employment-based adjustments, these developments offer both new opportunities and challenges. The latest rulings and procedural adjustments could streamline your path to securing status and benefits. Understanding these changes is crucial for staying on top of your application process and ensuring you meet all requirements. Here's a look at the most recent updates and what they mean for you. If you are interested in this, so to get all the information, pay attention and watch the video through to the end. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. So, without any further delay, let's jump into the video. Positive updates on family unity and employment-based adjustments. There have been some promising developments regarding family unity cases and employment-based adjustments that could significantly impact your application process. Family unity cases and parole in place. Recently, a notable case concerning family unity and parole in place reached the Fifth Circuit Court of Appeals. The court has issued a temporary freeze on the lower court's ruling, which had imposed an injunction affecting USCIS's ability to process these applications. This means that USCIS can continue to accept applications for parole in place while the matter is reviewed further. The initial expiration date for this ruling was set for September 23rd, but with the new extension into October, this development brings positive news for those awaiting decisions. If you are applying for parole in place, ensure you gather and submit 10 years' worth of evidence demonstrating your physical presence in the United States. File your application online to keep everything streamlined and up to date. Employment-based adjustment filings. On the employment front, USCIS has exhausted all available employment-based visa numbers. Despite this, USCIS has confirmed that you can still file adjustment of status applications throughout September, even if your case is not yet current. This is a significant advantage, as it allows applicants to maintain their positions in the queue and avoid unnecessary delays. Looking ahead to October, the visa bulletin has shown encouraging signs. The bulletin indicates that many employment-based categories are now marked as C for current. This means that you can proceed with your adjustment of status applications from October 1st without worrying about visa number availability. In previous years, when visa numbers were exhausted, applicants had to wait until the numbers were replenished before their cases could be processed. However, this year, USCIS is continuing to accept and process these applications, which is a significant improvement. Moreover, USCIS has been waiving interviews for many employment-based adjustment cases, which further speeds up the processing time. For instance, a recent case was approved within just 4 months without requiring an interview, highlighting a more efficient approach to handling these applications. Challenges and legal updates. Despite these positive developments, there are still challenges, particularly with the increased issuance of requests for evidence for O1 and EB1 cases. These RFEs are often boilerplate and can be time-consuming to address. However, recent district court rulings have provided some relief. Although these rulings are not binding, they offer valuable guidance on how to handle RFEs and appeal denials. 2 notable district court cases have emphasized the need for USCIS to adhere to established rules, such as those outlined in the Kazarian case. This case underscores that the evidence provided should meet the standard of preponderance of the evidence, meaning it must be more likely than not that the evidence supports the applicant's claims. For those dealing with RFEs, it's essential to follow the detailed guidelines provided by these recent cases. They outline specific factors that USCIS must consider and offer insights into effectively responding to RFEs. Overall, these updates represent a blend of positive news and ongoing challenges in the immigration process. While there are encouraging signs for both family unity and employment-based adjustments, it's crucial to stay informed and prepared. Keep track of the latest visa bulletin updates, ensure your applications are filed correctly, and be ready to respond to any RFEs with the thoroughness and clarity that these recent rulings suggest. These recent U.S. immigration updates bring a mix of positive changes and ongoing challenges. With the extension of deadlines and the easing of some procedural hurdles, there are new opportunities to advance your applications for both family unity and employment-based adjustments. However, staying informed and prepared is essential, particularly when dealing with RFEs and navigating complex legal requirements. By keeping up with the latest developments and following the outlined guidelines, you can better manage your immigration process and increase your chances of a successful outcome.
That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully the information is useful to you. See you later in the next video.
Hello everyone, welcome back to channel US Immigration. We hope you're doing great. In this video, we will talk about the key updates of family unity and employment-based adjustments. Recent updates in US Immigration have introduced significant changes that could positively impact your application process for both family unity cases and employment-based adjustments. In a recent development, the Fifth Circuit Court of Appeals has temporarily halted a lower court's injunction that had restricted USCIS from processing parole-in-place applications. This freeze allows USCIS to continue accepting applications for parole-in-place while the appeal is under review. Initially set to expire on September 23, the deadline has been extended into October, providing additional time for those waiting on decisions. Applicants should ensure they submit the 10 years worth of evidence showing their physical presence in the US and file their applications online for a streamlined process. For employment-based adjustment filings, despite USCIS having exhausted all available visa numbers, applicants can still submit their adjustment of status applications through September. This provision enables applicants to maintain their position in the queue and avoid unnecessary delays. The October Visa Bulletin reveals that many employment-based categories are now listed as C for current, which means applications can proceed without concerns about visa number availability. This is a notable improvement over previous years when applicants had to wait until visa numbers were replenished. Additionally, USCIS has been waiving interviews for many employment-based adjustment cases, leading to faster processing. A recent case was approved in just 4 months without an interview, reflecting a more efficient handling of applications. However, challenges persist, particularly with the increased issuance of requests for evidence for O1 and EB1 cases. These RFEs can be burdensome and time-consuming. Recent district court rulings, though not binding, offer valuable guidance on how to manage RFEs and appeal denials. These rulings underscore that USCIS must follow established rules such as those outlined in the Kazarian case, which requires evidence to meet the preponderance of the evidence standard. Applicants should adhere to the detailed guidelines provided by these rulings to effectively address RFEs and navigate the immigration process. Overall, while there are encouraging developments, staying informed and prepared is essential for a successful application.